Hello Paddocks Club members, my name is Jennifer Clements, I'm Graham's daughter and I'm coming to you from Victoria in Australia yet again. I don't know if you saw the video that I did last time, but I thought that we'd carry on with the theme of comparisons and look at another interesting provision that we have in the Owners Corporations Act in Victoria and compare it to the Sectional Titles Act and the prescribed management rules that apply in South Africa. So what I'm going to talk about today is an owner being unfinancial and what that status actually means and what the implications are for an owner who is considered to be unfinancial. So first of all, what does that mean? That means that an owner is in arrears. So they haven't paid contributions which are due to the body corporate or the owners corporation, depending on which country you're in. That depends on what terminology you're going to use. But basically, in terms of the Victorian legislation and the South African legislation, there's a very similar provision. In Victoria, it's Section 94 of the Owners Corporation Act, and in South Africa, we have Prescribed Management Rule 64A, and both of those say that if an owner is in arrears or unfinancial, they are not entitled to vote for ordinary resolutions at a general meeting. So that means that they are still entitled to vote for special and unanimous resolutions, can never take that right away in terms of the two acts. But I want to tell you how the Victorian legislation goes slightly further. So in terms of the Prescribed Management Rule 64A, except in the case of a special or unanimous resolution, an owner is not entitled to vote if any contributions in respect of his or her unit have not been duly paid. Now, in terms of Section 94 of the Owners Corporation Act, it says pretty much the same thing, except it goes on in another section, which is 103, 7A, if you're interested, which actually says that an owner who is unfinancial is not entitled to be elected as a trustee or committee member, as we call it here, and also that if a person is a committee member or a trustee and then becomes unfinancial or goes into arrears, they are suspended as in that office, so they're not a trustee or committee member for the time that they are in arrears. So basically that means that it's a big incentive, I suppose, for anybody who wants to be a trustee or who is a trustee to pay their levies and contributions on time, because if they don't, then they either won't be able to be elected as a trustee or they won't be able to act in their position as a trustee for the period that they are in arrears. Now, I think that's really good, because the trustees of the body corporate or the committee members of an owners corporation should be role models to the rest of the owners, and the fact that they're leading the scheme by being delegated the powers of the body corporate or the owners corporation means that they have a sense of responsibility and they should be acting as they would hope that the other owners act. So the South African legislation hasn't gone as far as to say that if you are in arrears, you can't be a trustee, or you will be disqualified as a trustee, or you'll be suspended as a trustee. I think there's Prescribed Management Rule 13, which deals with the disqualification of trustees, and it goes through a number of situations where a trustee would be disqualified and would have to step down from office, but it doesn't include the situation of that trustee actually being in arrears. So I think that's quite interesting. Another way that the Victorian legislation goes slightly further than the South African legislation is that the South African legislation only looks at when an owner is in arrears, that they can't vote at a general meeting, whereas the Victorian legislation actually goes further and says they can't vote at a general meeting or for the purposes of a ballot, which is like a round-robin procedure in South Africa. So that means that basically if you're in arrears in Victoria, your vote for any ordinary resolution is not counted, whether it be by yourself in person at a meeting or by your signature on a round-robin or ballot document. You're not counted. Obviously there's the exceptions that you can be included in the special and unanimous resolutions that take place during the time that you're in arrears, but for any ordinary resolutions, you're done. So thought I'd share that with you. Hope you found that interesting and useful, and we'll see you again soon. Have a good day. Bye.